Number 38, People versus Michael Saenger. My apologies. Give counsel a minute to settle.
Sorry?
Oh, go ahead. Thank you.
Good afternoon. Sam Feldman for appellant Michael Saenger. I'd like to reserve 2 minutes for rebuttal, please.
Yes.
This court has laid out 3 essential purposes that an indictment serves in People v. Sanchez and other cases. And the count of the indictment in this case that charged aggravated family offense failed to accomplish any of those purposes. The first purpose is notice. The indictment provides the defendant with fair notice of the accusations made against him so that he will be able to prepare a defense.
Counsel, I may agree with you if the indictment had 30 or 40 crimes on it, but looking at the 4 corners of this indictment and the fact that only one of the crimes met the specifications, how can you argue that the defendant didn't have notice?
It's true that one other count of the indictment was a qualifying offense, but the problem is the qualifying offense did not have to be charged separately in the indictment. So while that other count could have been ultimately turned out to be the underlying offense, there was no basis for defense counsel to assume that it was.
And with respect to these CPL, do you look at each individual count as to its sufficiency, or do you look at the whole indictment to determine whether or not that individual count is sufficient?
You can look at the whole indictment, but each individual count is jurisdictionally defective or not on its own.
And one count doesn't mean, of course, then if it's defective, that the whole indictment would have to be dismissed.
That's correct.
So in this particular instance, you have a charge that says it refers to a number of misdemeanors. Is that the issue here?
Yes, many misdemeanors that are listed in the statute that it could have been, which is why the mere fact that that count cited the statute did not actually specify what it was that Mr. Saenger
But there was only one of those, of the 50 that are listed, was actually on this indictment. So I understand your argument, and I sympathize with it if we were talking about an indictment that had, even 10 or 15 counts, several of which would have fit. My concern here is, as you mentioned correctly, an indictment is to give notice. So I don't know how, not reading the 4 corners of this indictment, you don't have notice of what the specific crime is. And to your point about it doesn't have to be a charged crime, does the fact that it is a charged crime and the defendant was already defending against that, doesn't that also go against your argument?
Well, let me put it this way. Let's say that counsel assumed that because second-degree criminal contempt was charged separately, that must be the underlying offense, prepared for trial accordingly, shows up to trial, and then at trial, perhaps at the charge conference, which is where it was eventually specified here, the prosecution says the underlying offense is menacing, third-degree menacing. Counsel would have no basis to complain if the indictment is jurisdictionally sufficient.
Is that what happened here?
No, here, as the transcript makes clear, the judge and defense counsel showed up to the charge conference having no idea what the count referred to, and the prosecutor said...
And how many misdemeanors are referred to in the section?
I believe it depends on how you count. I think there's 50...
Well, there's 54 offenses, 36 felonies, and 18 misdemeanors.
Right, well then in that case 18 misdemeanors would be the number.
So if you're the accused, how do you know which one, how do you check to see if the grand jury indicted the defendant based on what the people claim they did, or that later on they decide, no, we're going to substitute it for another?
Right, exactly, Your Honor. And that goes to the second purpose of an indictment that this court laid out in People v. Sanchez, which is that it provides some means of ensuring that the crime for which the defendant is brought to trial is in fact the one for which he was indicted by the grand jury, rather than some alternative seized upon by the prosecution. Here there was no such constraint.
But what about Judge Sengis's argument that, well, that one of those misdemeanors was in fact charged in the indictment, in another count?
True, but again, that didn't constrain the prosecution. Nothing would have stopped the prosecutor at that charge conference from saying the underlying account here is criminal obstruction of...
I get that, right? But that's not what happened here, right? So we're looking at the facts of this case. And in this case, that scenario didn't happen. And I believe the defendant did have the opportunity to review the grand jury minutes as well. So having reviewed the grand jury minutes and reading the indictment, I'm having trouble trying to figure out why the notice requirement wasn't satisfied. In this case, I hear what you're saying generally.
Well, I think there's sort of two answers I'd make to that. First, I think that would go to a prejudice analysis, what happened in this case, but there's no prejudice required for a jurisdictional defect. I mean, this court has said in People v. Dryden, the test for a jurisdictional defect in the accusatory instrument is simply whether the accusatory instrument failed to supply defendant with sufficient notice of the charged crime to satisfy the demands of due process and double jeopardy. So for that, we don't look at what happened at trial. We just look at the accusatory instrument itself. And second, just as to the access to grand jury minutes, because the indictment itself did not specify or constrain the prosecutor to one particular charge, in a way, the evidence before the grand jury wasn't really the relevant.
Did the bill of particulars help clarify things?
It didn't, because it didn't specify which of these many misdemeanors it could have been. It just basically repeated the allegations again, which could have supported multiple misdemeanors from that list. And finally, just for the sake
But
of...
you concede if it had listed at that point, because you do actually look, or you can look, beyond the four corners of the indictment, because one can look at the bill of particulars, correct?
Yes, that's true. The bill of particulars can cure the defect in the
But
indictment
that,
itself.
your position is that's as far as you can go. You can't, if it's jurisdictionally defective, you can't then look at what may have gone on at trial or a charge conference or something else.
Yes, that's right, exactly, Your Honor. And for the sake of completeness, I should mention the third purpose of an indictment, which wasn't served here, which is the double jeopardy function. An indictment protects a criminal defendant from prosecution at another time for the same offense. Again, that's quoting from Sanchez. This count of the indictment basically said, you know, Mr. Saenger did one of many possible things in the county of Queens on this date. In a future prosecution, that wouldn't really be enough to point to say
But would
whether
the
or
bill
not...
of particulars help you with that? I mean, it does lay out the conduct. I'm not sure what the double jeopardy rules are exactly in that context, but could you be prosecuted for one of the other crimes related to the conduct in the bill of particulars?
I would, if the future indictment...
Was based on that same conduct, right? I mean, granted, it could be multiple crimes based on that conduct that could have been used as the crime here, but let's say there's a conviction and they go with the one they pick, could you then be, your client then be charged with another crime based on that same conduct?
So in other words, could you point to the bill of particulars to raise a future double jeopardy? It's an interesting question. I don't know that there's a case that settled that in one direction or the other about whether you can use a bill of particulars for that. So I guess we'd have to say it's an unsettled question as far as I know. I'm happy to address further questions on that issue, but actually I see my time is up, so save it for rebuttal.
For the Office of Melinda Katz, Assistant District Attorney Danielle Fenn, for Respondent, may it please the Court. I would like to address the ineffective assistance of counsel claim.
Well, counsel, could we start with this issue first? And
Yes.
my question is, notice of what do you have to give them? Because we could parse the indictment and say, you know, okay, this other count is the one you meant, or we can look at the conduct and say, does this meet the elements of these various other crimes? But what's to stop the prosecution from getting to the charging conference and having one idea in their head, maybe we were going to charge one of these other things, but hey, we didn't really make that, so no, we really meant the one we charged in count 4.
In terms of this case, notice requires, for this statute, notice required that he's charged with aggravated family offense. And here, there was only one count in the indictment that would qualify as a specified offense. So this defendant
Sure, but it
had-
doesn't have to be charged in the indictment, right?
That's correct. It does not have to be charged in the indictment, but here it was. So
So
in this
since it
case-
doesn't have to be,
I'm sorry, it's charged in the indictment as a separate crime, and I think in that sense, the defendant certainly has noticed that he's defending against that conduct and that charge. But there may be other elements to a different crime that you may have in your head that you're going to use as the crime in the other count. You didn't know that, right? So it just comes down to me, there's two ways you can do this. You could, well, it's three. You could put what you mean in the indictment, you could do it in the bill of particulars, or we could do what we're doing here. And it seems to me that the best way would be one or two. And why would we encourage three?
1 and 2, either specifically saying the specified offense to wit and fill in the blank.
Right.
Or the bill of particulars, that may
And
very well
neither
be
of
the
those
best
things
practice.
do that here.
That's correct. That may be the best practice, but here it wasn't fatal because defendant did have notice of the crime that he was charged with, the specified offense, because it was separately included in the indictment. So one of the purposes of the indictment is to provide notice so the defendant has information so he can defend against the crimes he's charged
Maybe
with.
you meant something
And
else originally. Maybe you had a different crime in mind for that, and then you get to the end of the trial, you realize you haven't proved it, and you're like, no, we meant the charge underlying the other count. How do we know that's not true?
Well, in this case, it was the indictment and the separate charge, but it was also the information in the bill of particulars because that only supported the criminal contempt. The defendant, when he was charged with the felony complaint, was charged with obstruction of breathing, and now defendant posits that that might have been something the prosecutor could have used as a specified offense. But the information in the bill of particulars excludes that because the defendant didn't choke the complainant. Her breathing was never obstructed.
Well-
So I'm sorry.
With respect to the CPL, do you look at the sufficiency of an individual count? And when you look at an individual count, does it itself have to be sufficient? Do all the elements do they have to make out a crime?
Yes, I believe every count in the indictment does have to be sufficient, but in this case it was because it was incorporated by reference. The language with all of the 50-odd.
How is the defendant to know that? Just because it happened to be there?
No, because this court has held that incorporation by reference is sufficient.
That is when it is clear it's referring to a more limited indication. You can refer to the particular section, but it's one crime. Here, there were a number of misdemeanors that it could have been.
Yes, there are a number of misdemeanors listed in the statute.
And why isn't it the people's responsibility to make it clear to not only the defendant, but also to the grand jury, here's the crime?
In this case, it was clear to answer that question in reverse. In terms of the grand jury was charged that the specified offense was criminal contempt in the second degree. And at the charge conference, the prosecutor did tell the court, the way we charge this in the grand jury is that they're given the charge.
The court
prosecutor
seemed
reads it.
confused.
The court merely clarified it, and it wasn't that the court.
But isn't the notice, when you get the documents, not when you're at a charge conference? The point of the notice is not at the back end, right?
But in this case, the facts of the case show that defendant did have notice because he never said, he had the opportunity to
Because
raise
it's
his
one,
claim
because
to any-
there's only one count that fits
There's only one count that
the
fits.
qualifying offenses.
Yes, Your
And
Honor.
that is listed. Let me ask you this. Do you agree with what Judge Saenger had mentioned before when she was asking questions of your adversary, that it would be different if there was more than one count that would have been a qualifying offense that was charged in the indictment? Do you agree that that would be different? Because then the defendant doesn't know which count is the qualifying count the prosecutor's relying on.
Yes, Your Honor.
Okay, so
And-
then I'm having difficulty seeing the difference between that, if you concede that, and one is listed, but at the charge conference, they could rely on something else because it doesn't have to be listed as a separate count.
In that case, well, to go back to the facts of this case, it was the fact that it was separately charged and it was the only crime in the bill of particulars that would have fit. Because in a hypothetical situation where there are 50-odd crimes that it could be under the statute, and maybe there were other
Okay,
options.
so then, is it your position that because there's only that one count, it's the one that is a qualifying offense, that the prosecutor couldn't do what counsel is saying, which is rely on evidence that makes out a different qualifying offense that's not anywhere in the indictment or the bill of particulars.
Yes.
Does that mean that the prosecutor would then have been limited to that one count, and that's why there's notice?
Yes, the prosecutor, and that's exactly what happened here, where the prosecutor said it's criminal contempt in the second degree. The court repeated that. Defense counsel never said
Why are
anything
then
at
there
the charge
questions
conference.
about it? If it's
I'm
the
sorry?
only one that fits, why is there uncertainty about it?
Well, there was an uncertainty because defense counsel could have objected to this and said, once after he was arraigned on the indictment, he could have raised this claim, but he didn't. And even at the charge conference, when the court said, so the prosecutor is saying the specified offense is criminal contempt in the second degree,
But you
defense counsel
do
never
agree
said.
in the first instance with respect to the jurisdictional sufficiency, that is the people's responsibility, correct?
Yes, the people have to have a jurisdictionally sufficient indictment, and
And it's not unduly burdensome to pick from the list and so specify within that particular account.
that is, as Judge Garcia said, there are several ways of doing it, and that is certainly one, and that may be the best practice. But here, this was not fatal because it was the only count on the indictment that could have fit in the facts of the case that was
So he
consistent
couldn't
with the bill
think
of
that
particulars.
maybe, even though the obstruction, because he put his hands around her throat.
Yes, Your Honor. With that crime, he was charged with that in the felony complaint, but then he wasn't indicted for that. And the information in the bill of particulars shows why, because the complainant pepper sprayed him before he pressed
Apply
down.
pressure. So he's
that's-
supposed to, because he has sufficient facts, you're saying, he can just simply eliminate the other crimes and know for certain that it was the one that appears in a different count.
Yes, in this case, this was the only crime that constituted a qualifying offense that was also separately charged. And one of the purposes of the indictment is the defendant has notice of the crimes
And
that he's
that's
defending
his
against.
duty to do, not the people to specifically specify.
But in this case, of course, defendant needs notice. The people have to give defendant notice. But in this case, he did have notice. And just the facts surrounding, say, the charge conference or the pendency of the case till the
He
trial.
does have
never-
notice, I agree with you, of that charge as to a separate count. But the question is, does he clearly have notice as to the count where it doesn't specify which misdemeanor?
It's the fact that the incorporation or reference by the statute and listing 24075, and then the information provided in the bill of particulars and the fact that this is the only charge that.
So your argument really is most persuasive, or really works, let me put it that way, taking the concession you made before, which is that, given that that count that is listed in the indictment is a qualifying offense, it's the only one there that is a qualifying offense, that is what the prosecutor would be limited to. That is to say, they could not have chosen to argue a different qualifying offense.
That's
Seems to me
correct.
that's the only way your argument makes some logical sense.
That's correct. In this case,
I just don't know that you're correct, but
Is
And
that,
this-
is that the CPL standard? Is it that the defendant has to engage in some process of deductive reasoning to say, well, I've eliminated every other possible predicate offense, and all I'm left with is this one that's charged elsewhere in the indictment, so that must be it? Is that the pleading standard?
no, Your Honor. And in this case, the people are not asking defendant to make these huge logical leaps or follow a breadcrumb trail. In this case, it was the only count that was alleged in the indictment that was
Well,
separately
he has to
charged.
prepare a defense, right?
Yes, and he did prepare a defense for this charge because it was separately charged, the secondary contempt. So it wasn't a case where he was caught short and he didn't know or it was a surprise. He was always going to prepare for second-degree contempt. That was charged, what was charged to the grand jury. It's what the prosecutor maintained and represented to the court during the charge conference. And defense counsel apparently understood this because he never said at the charge conference, wait, this wasn't what I was expecting.
Counsel, one last thing with the Chief Judge's permission. If there was another qualifying offense that was that you could use the facts in your bill of particulars to support, would you then lose?
In the bill of particulars, in,
You're saying the facts of the bill of particulars only supported that one charge, which is laid out in the other count, but if it supported another qualifying offense, would you then lose?
if there was something, if it was a situation where he was charged with multiple
No,
offenses,
that's not my
or-
question. My question is, I think you've been saying that if you look at the indictment and there's this other qualifying offense charged in a separate count, and you look at your bill of particulars conduct, there is only one qualifying crime that could be supported by this conduct you've alleged in your bill of particulars. Am I wrong in that?
Yes, that's correct.
So if that were not true, if there was another qualifying offense that you could charge based on this same conduct, would you lose?
I think that in that situation, where there was an ambiguity in the bill of particulars, or there could be multiple crimes, it would still be based on what the indictment is. It would still be the qualifying offense, the specified offense would be criminal contempt. This is in a situation where if,
So it
in a
doesn't matter if
hypothetical-
you had more than one crime that would be supported by your bill of particulars?
In this case, it was only the second-degree contempt, because it wasn't supported by the information in the bill of particulars. It was the only crime that was supported by the bill of particulars that was separately charged, and the defendant understood that this was the specified offense. I would like to note that as the appellate division incorrectly ruled, this claim regarding the aggravated felony offense is unpreserved, and it was not a jurisdictional defect, a jurisdictional claim. It does require preservation, and here defendant failed to raise it below, and thus.
You take
it is-
30 seconds to address the ineffective assistance. I
In
know
this
you wanted to
case-
start with that, so you have your red light, but
Thank you. In this case, defendant received effective assistance of counsel. The single error that's alleged is not so clear-cut that it overshadows or taints the entire representation. In this case, based on the fair reading of the statute, the legislative history, and also the CJI instruction, defense counsel fairly understood, along with the court and the prosecutor, that.
So let me ask you this, do we have to resolve the statutory interpretation question to rule against the defendant? Or to rule in your favor, I should say?
I think if the court finds that it wasn't clear-cut, then defense counsel would not be ineffective, because for a single error Turner case, it has to be clear-cut and dispositive. In this case, if there was ambiguity, it would not be a clear-cut
It
claim.
might be
that-
better to resolve it, no?
I'm sorry?
Might be better, let's say we agree with you that there's ambiguity, better to resolve it, no?
Well, in this case, in terms
As opposed to
of,
just say there's ambiguity, so yes, it wasn't so clear-cut what your argument, I understand your argument.
to the extent that there's a claim about the legal sufficiency of the first-degree contempt case, in that case, that's not before this court, because it's now in the posture of an ineffective assistance claim, and defendant did not preserve that legal sufficiency claim below. So this court is really, the claim before it is this ineffective assistance, and this wasn't a clear-cut claim such that counsel was ineffective for failing to raise this single claim when he received a meaningful representation. Counsel had a valid strategy that ended in the acquittal of 3 of the counts, and the single claim about the first-degree contempt count was not clear-cut.
Thank you, counsel.
Thank you.
I'd like to address the ineffectiveness point also, unless, of course, the court has further questions about the jurisdictional defect point. So I don't, to sort of address Judge Rivera's question, I don't think the court needs to resolve the statutory interpretation question here about whether or not the statute does require a prior violation of a stay-away provision, because at the time of trial and since, every court, every judge, in fact, to address this question had come down the same way and had said that the statute does require that. So whether or not this court would agree with that de novo, and I'll get into why I think the court should agree with that consensus, that was certainly enough for any competent.
Yeah, but if we conclude that that's an incorrect reading of the statute. Then it's, right, a claim eventually that would have failed, how are they ineffective?
Well, I mean, I guess what I'd say is,
Presciently realizing the court would have found it incorrect?
I think that there was certainly enough here to convince the trial judge, which is what immediately mattered, that this count needed to be dismissed, based on there was prior Supreme Court precedent, there was the First Department had addressed it unanimously, and then, of course, since the
But
trial.
then it would be ineffective for not getting it improperly dismissed?
Improperly, you mean because?
If we reverse that, if we were to reverse that holding, I mean, then subsequently, we would have decided, no, that's actually not the way you read the statute.
Well, it's an interesting question. Of course, we'd have to consider whether the case would even have gotten to this court. But it does seem like perhaps the court wants to get into the actual statutory interpretation question, so I'm happy to.
But actually, even before you get to that, I mean, if it's unsettled in some way, maybe there's a reason why this defense lawyer wouldn't raise it, right?
Well, I guess I'd say two things. First of all, I don't think there was any sense in which this was unsettled at the time. Again, every judge to look at this statute had said it requires a prior violation of a stay-away provision. And again, every judge since then has also unanimously agreed with that.
I can see, though, an alternate reading of it, right, that says the order has to have a stay-away provision in it.
Yes, I think, so the actual language of the statute, the key words are as described herein. There is a reading of it, which again, no judge to look at it has endorsed, but there is a reading of it that it would refer to a different part of that confusing paragraph. But I think that is where the rule of lenity comes in. If there are two possible readings of this statute, then of course the rule of lenity says to construe it in the way that's more favorable to the criminal
Well, and if
defendant.
it's unsettled, what's the strategy behind not raising it?
Right, exactly. That's the other thing. There was absolutely no downside, only upside to raising this issue. It required, no weighing of competing objectives at trial. It required not even any investigation because the prosecution put it on the
You
record.
could say that with anything, like Sean John, we changed the rules on witnesses for DNA. Trial counsel in that case raised it. I mean, there's no harm in raising that, right? I mean, even if they would have lost, so is every counsel that didn't raise the Sean John issue ineffective?
I would point to, I think what the Supreme Court of the United States has said on ineffectiveness is that, specifically as regards factual investigations, is that, counsel should either do reasonable investigations or refrain from doing them in a way that's reasonable, so you don't have to, search every corner of the earth necessarily. I think a similar thing applies to statutory arguments like this. Had counsel done the slightest research on what the elements were of this offense that was one of the 6 counts in the indictment, he would have turned up every case pointing the same way, that it did have this element that the prosecution had already stated on the record wasn't met here. So it didn't require a lot of sorting through case law. It didn't require figuring out what the rule is. It didn't require making a novel argument, not anything like that, certainly not with DNA, which requires, a fair amount of study to get your head around. This was really just a matter of what do the cases say the elements are? They all say this, that element isn't met here. And I think that's enough that counsel should raise it in some way as part of the bare minimum of effective assistance.
Thank you.
I'm sorry, can I just, sorry, my apologies. I wanted to let you get to the IAC, but I just had one question to go back on the other issue, the same line of questioning I was asking the Assistant District Attorney. So what is your view of this point as to whether, if indeed this is this charge is the only qualifying offense that one can fathom from the indictment and the bill of particulars, but then they couldn't do what you had proposed before, which is then make some other argument at the charge conference?
Well, so first let me just make sure I'm understanding the question. In other words, if, based on the indictment and the bill of particulars, you could only imagine there being
Yes.
one charge that's supported
Yes.
by those factual allegations. I guess
Which is closer to Judge Garcia's question, obviously.
one point I'd make is that even looking at the indictment and the bill of particulars here, for example, I would say it doesn't seem like they could make out third-degree assault based on those allegations. But maybe the prosecution thinks otherwise. Maybe that is what that count refers to, and you just have a really good defense against it at trial, which is this doesn't amount to physical injury. In other words, the fact that you have a good defense against a charge or that the prosecution's unlikely to be able to prove it based on these allegations, it doesn't mean that's not what's charged. There are charges that get brought and tried that, the evidence doesn't end up supporting, or even the bill of particulars doesn't support. So that's one answer I would give to that.
Thank you.
Thank you.